And just because you're a public official doesn't give a person a right to insult with vulgar language in a public place.
Gonna have to stop the recording. Duty, back up.
Hello, good morning. Morning, Mr. Garza.
All right, courthouse session de la presiding. Good morning, buenos días. Tomen asiento, por favor. Court calls out case number 2024, NP 000165435. My name is informed. Please come forward. Good morning.
Morning, sir.
English is okay for you?
Yeah, English is fine. How are you, sir?
Good morning.
All right, we're here on a couple of pre-trial issues, and I want to let both of y'all know that we're going to cover a couple of things this morning. First, we're going to cover a motion, a pre-trial motion to dismiss that was filed by Mr. Rincon. And then we have other pre-trial matters that deal with subpoenas, okay, that we're gonna cover as well. Okay, so those two issues are the issues we're gonna cover this morning. Are both of y'all ready to proceed with this matter?
Yes, sir.
Yes, all right. We'll start with either opening statements or oral arguments from the state, and then we'll give Mr. Rincon the opportunity to respond.
Well, as far as the motion to dismiss, Judge, I filed a response. I believe the court received my response also. The court also forwarded a response to the defendant.
Is that correct, sir? You got a copy?
Yes, I just want to make a note that it was sent to me yesterday,
Do you need
uncalled.
time to prepare, or
I mean,
is that all?
I would like to have a chance to respond to it, but I mean, I'm already here. So.
Okay, but it really depends. I want to make sure that this proceeding, that you have a fair chance to enter your response, and that the state is ready as well. If need be, and you need a couple of days, the courts will be more than glad to give you a couple of days and move it to a different date. That way you'll be ready. I don't want to kind of force you to do something quick when you're not ready.
All right.
That's not the court's intention. So, are you asking for days to prepare?
No, at this point, I think we have already rescheduled it way too long, and I think I'm ready.
So you're ready to proceed?
Yes, sir.
Okay. The state's ready?
Yes, Your Honor.
All right, go ahead.
Okay, so, Judge, of course, we object to the defendant's motion to dismiss. He cites, of course, the First Amendment. However, the First Amendment is not, of course, without its limits. That's why we have the section, Penal Code of Disorderly Conduct, to where if, in fact, the speech gets unruly, vulgar, and so on, as deemed in the statute, as outlined statute, it does become limited and subject to sanction by the authorities. And so that's what happened in this case. And so we filed our response, and we object to the motion to dismiss. We would ask the court to dismiss his motion to dismiss, leave this case on for trial, and send it for either a bench trial or a jury trial, so we can proceed.
Okay, and in your response in the argument section, that's what you stated, section 4201, subsection A1.
Yes,
And okay.
that's what was cited, that's what you were cited on. That's because 4201, as the court knows, is a very lengthy statute. It covers a wide variety of conduct that rises to the level of disorderly conduct. And in this case, it was specifically A1, where the defendant used vulgar language at a public place.
All right, we'll take that as your opening statement. I'm gonna allow Mr. Rincon to give his opening statement, and then we'll go back for arguments, because you cited a couple of case law, and that was during your argument point. We'll discuss the case law. Go ahead with your opening statement, sir.
Yes, sir. As you know, And I'm going to use the word that was used in this specific case without any disrespect to this court. Simply saying or the utterance of the word fuck is not against the law. It's the most protected word in the U.S. to this day. I cited case law that pertains to the word being used in a courtroom such as this right now. The person was not convicted or was not able to be convicted because it was protected speech. And it was the same word that the state is trying to maliciously bring these charges against myself. I cited, of course, Cohen v. California, which is the most known case for saying the word fuck the draft that this person had in a jacket and was arrested and was not appealed his decision to the Supreme Court, and the Supreme Court held that he cannot be convicted for having that specific word. Also, there are no witnesses that state any crime. There's two statements. Those two statements belong to two public officials. One is a teacher and the other one's a superintendent. And the only thing that they say is that one of them felt threatened, harassed, and intimidated by the word that was uttered. And as you know, anybody can feel a certain way by any word. It doesn't have to be the specific word that was used in this case, but anybody can be threatened or harassed by any word. And there's no crime listed or mentioned in any of those statements. And like I said, everyone that was present, or the most part that was present, they were acting in their official capacity. They were public officials, employees, and elected officials. At least I didn't receive any witness statements from any members of the public, which is a requirement for this statute. Also, the statute says that 4201A1 says a person commits an offense intentionally or knowingly, uses abusive, indecent, profane, or vulgar language in a public place, and the language by its very utterance tends to incite immediate breach of the peace. There are no facts, Your Honor, that anybody breached the peace in this case, or anybody attempted to breach the peace. And what is breach of the peace? So somebody committing a crime because of the words I said. There are no facts, there's no statements that somebody attempted to commit a crime because of the words I said. It's my opening statement, Your Honor.
Okay, all right. Go ahead, Mr. Garcia, with your arguments.
Your Honor, in response to that, he doesn't say what he said completely there at the meeting. So after the meeting was done, he basically yelled out to the superintendent and to other board members, not the word fuck, but he told them, fuck you, and he was deliberately addressing them with vulgar language, which is vulgar language as it's in the statute, the public place. And the point of the statute is that by its very own intents to incite a breach of the peace. It doesn't say that does incite a breach of the peace, that tends, in other words, that could incite a breach of the peace. And so therefore, he mentions that case in his brief, in his motion to dismiss, but in that it was in a different context. Okay, somebody wearing a t-shirt that says, of course, fuck the draft, that's totally different than somebody here pointing at board members and addressing them with vulgar language, which would tend to incite a breach of the peace. By the mere fact, the way he said it, he was shouting, he was yelling, he had to be escorted out of the board room forcefully. He tried to come back in. They had to, again, escort him out. He, in so many words, threatened another person, Mr. Perez, on his way out, which he will come and testify that he felt threatened by Mr. Rincon at the time. And so clearly the statute has been violated by Mr. Rincon in the way he said what he said and the way he directed it in that situation. There is case law that says that, you know, it addresses fighting words. And then again, the context is, depending on the way the context of the language of what is said, depending on how it's taken, it doesn't necessarily have to rise to that. There is case law that, you know, addresses that, but there's also case law that addresses that by the mere utterance of vulgar words, as the statute says, if it tends to incite, it's capable of inciting a breach of the peace, is sufficient for a violation of 42A1. It doesn't necessarily have to be fighting words, as some of the case law suggests, as long as the words are vulgar and that tend to incite a riot, and it is in a public place, which we have here, is capable of inciting a breach of the peace, then that's sufficient for the violation of the statute.
Can you elaborate which case law is that particular case law that you're mentioning too? I know the one for fighting words, but do you know which one exactly you're mentioning?
Well, Coggin addresses that. There's also excerpts from the same case that addresses that, you know, because that's the way it was done in this case. And so that's why I'm telling the court that there's different cases that, depending on how and what is said, that would be sufficient. This is an example of, there's very few cases that deal with actual just vulgar words. But it's our contention that by the mere utterance of vulgar words in a public place, that tend to incite a breach of the peace, that is sufficient for a violation. That's why it's in the statute in A1.
So we know that it has to be a breach of peace. In order for it to be a breach of peace, it has to conduct or contain fighting words. Any case law on fighting?
Not necessarily, Judge.
Okay.
And it doesn't have to create a breach of, in other words, you don't have to have the breach of the peace. The statute says that tends to incite a breach of the peace. Okay? You don't have to have that completed breach of the peace. That's not what it's saying. Okay? It's not saying that the vulgar words caused a breach of the peace. Okay? That's not what the statute says. If you read the statute literally, the way it is, it says that by the mere utterance tends to incite a breach of the peace. And so therefore, it's not addressing that a breach of the peace actually occurred, but that those words are capable of causing a breach of the peace. That's what the statute is saying. And so in this case, we contend that yes, by the way he said it, by the way he was shouting, by the way he was pointing at the board members and telling them, fuck you, in the video, he deliberately addresses the superintendent, tells the superintendent, fuck you, superintendent, you know, and then he addresses the rest of the board and says, fuck you, board members. And that's when the board members asked that he be escorted out. And he had to be escorted out twice.
Go ahead with your argument, sir.
Well, any word can be like the statute said, tends to incite. In this case, there's no witnesses that say that. In the two particular witnesses, two witness statements that we have, nobody states that they were trying to commit any sort of breach of the peace or they wanted to fight or something like that. The state is claiming that it tends to incite, but anything could incite violence, anything could incite a breach of the peace. But there are no facts to that. There are no facts in the witness statement that they claim that they wanted to harm me, they wanted to fight, they wanted to breach the peace. They didn't do it like the state is saying. They didn't commit any sort of violent reaction. They didn't yell back or they didn't do anything because I yelled. But they didn't even felt that they wanted to respond in a violent manner. They didn't claim that they wanted to do violence, or they didn't claim that they wanted to breach the peace because of the words that I said. And that's what it means when the statute said tends to incite a breach of the peace. Because anything could incite a breach of the peace. Any word can incite a breach of the peace. In his response to my motion to dismiss, he cites the statute Mary versus State, and that's not even relevant to my case. This was for 4201 AB, which is not the case for my specific case. I was cited for subsection 1, and in the case that was cited by the state, the court held that the utterance of profanity to a child directly. So this is not the case, like I was saying earlier. Everyone that was present was a public official, and as you know, that the word is the most protected word. You can criticize your government however you want without inciting violence. There was no members of the public that complained. There was no members of the public that issued a statement that they felt that they wanted to breach the peace or anything like that. Everyone that was present, and the 2 witness statements that we have are from public officials.
And the 2 witness statements, you said that one of them said that they felt threatened and intimidated.
Correct.
That's what you put on your defendant's motion to dismiss, is that correct?
Yes, Your Honor. I have the witness statement with me. And like I was saying, Your Honor, feeling threatened is not part of the statute. Anybody can feel threatened by anything.
Yes, you have the witness statement?
Yes, sir.
Can you pass it to us? Any objections against the witness statements?
No, I have this statement. There's also another statement from another individual that was there. Yes, I would like the court to see that one too. Yes? Yeah.
No objection to that one? No objection for the court to take judicial notice?
No.
So on Mr. Perez, there's no anything that said that he felt threatened. It was just Mr. Cruz. Is that correct?
Mr. Cruz indicates that he felt threatened. Mr. Perez, however, indicates that Mr. Lincoln looked at him in a menacing manner and shouted at him, "You want to tell me something?" And Mr. Perez said no, you know. And so that shows us the way he was comporting himself that day, trying to incite. Like I said, you know, he was being unruly, disorderly. There are those statement witnesses, and just because you're a public official doesn't give a person a right to insult with vulgar language in a public place. That's not the way these meetings are supposed to be run. Even after the meeting, people are supposed to comport themselves. If they have anything to say to public officials, they should address it in a orderly manner.
Objection, Your Honor.
In a vulgar statement.
Go ahead with your objection.
The objection is that he's misleading the court, Your Honor, with the statements that that's not the way to criticize a public official.
Okay, just objection overruled. Please rephrase the statement.
Judge, what I'm advising the court that just because a person is a public official does not give an individual, and like we said before, yes, you have a person on the right. It doesn't give a person the right to violate the disorderly conduct statute by uttering vulgar language in a public place that tends to incite breach of the peace. He's got the breach of the peace part wrong, where it says that nobody came at him. Maybe that's what he wanted to do, to incite maybe something to the way he videotaped and so on. But that didn't occur. But again, the statute says that tends to incite a breach of the peace, and it could be the breach of the peace. He could be causing it by what he's saying. That's he's getting it wrong as far as the statute is concerned, that you have to have somebody come at you and so on. That's not what the statute indicates. The statute indicates that by what you're saying, it tends to incite a breach of the peace by any party, not by the one saying it or the ones that are receiving it. And so that's my argument on that.
All right. Go ahead, Mr. Cooper.
Oh, when it says, I mean, the language is clear, tends to incite means that what I said tends to, for somebody else. If I violate the breach of the peace, I would be committing a crime. When it says tends to incite is that I'm making somebody else breach the peace. And like I said earlier, nobody claimed in their statements, not on Mr. Perez's statement, not on Mr. Cruz's statements. Neither of those statements make any claims, any sort of claims that they wanted to react in a violent or wanted to breach the peace in any way. The simple feeling of feeling threatened or harassing is subjective, Your Honor. As you know, I can feel threatened by somebody wearing certain colors. I can feel threatened or harassed by anybody just speaking to me. There's nothing in this voluntary statement, Your Honor, that could convict me for violating this statute, Your Honor.
Closing statements, Mr. Garcia.
Your Honor, closing, the court has seen the statements. The court has seen our response to defendant's motion to dismiss. And we submit to the court that the defendant did violate the statute by uttering vulgar language, not only once but twice, to the superintendent and then to the other board members. And then on the way out, he also confronted a citizen outside, and so he clearly violated the statute by uttering vulgar language, by saying "fuck you," but by the way he was saying it, and having to be escorted out by police from the building clearly shows the court his intent of what he was doing. He clearly wanted to incite a breach of the peace by the way he was comporting himself and the way he was acting, and clearly he did it by what he said. And so it was in a public place, and by what he was saying and the way he was saying it could have caused, and that's what the statute says, could have caused a breach of the peace. And so we would ask that the court dismiss his motion to dismiss.
All right. Closing statements, Mr. Rico.
Oh, Your Honor, I think everything that I wanted to say was already covered. As I said in my opening statement, the utterance of the word "fuck" is the most protected word in the United States, in the United States courts, including the Supreme Court. And in this case, the only two statements, Your Honor, are from public officials. The state is trying to mislead the court that there was one citizen that complained. There was no citizen that complained. There was everyone that was present, or everyone that submitted a statement in this case, Your Honor, was a public official. They were on the clock. They were acting in their official duties. Therefore, criticizing them by using these words is clearly protected, as you know, Your Honor. There was no breach of the peace. There was no incitement of breach of the peace. The simple words cannot be used as a basis for bringing up these charges, Your Honor. That's all I have.
Can I respond to this?
Yes, go ahead.
Okay, so, Your Honor, if we tend to follow what the defendant is saying, he's trying to play it down that he just said "fuck." No, anybody can walk around and say "fuck, fuck, fuck," like disgruntled or whatever. But when you're addressing it to someone and pointing your finger and telling them not fuck, he's telling them "fuck you," in an angry manner, and that tends to incite a breach of the peace. And not only is he doing like that, you take him out, he comes back again, and he does it again. And so therefore, we stand by what he did is a violation of 42A1.
All right, go ahead.
Well, I've been saying that over and over. there's no facts that state what the state is claiming.
You know, I have a video, the court wishes to watch the video so that it can help the court in making a decision as far as, he's trying to play it down like, you know, fuck. No, that's not what he said. The video clearly shows it.
Okay, any objections for the video?
I want to finish my statement first.
Let him finish, first, and then we'll discuss the, okay, go ahead.
Like I was saying, there's no facts at all. The witness statements, there's no facts in the police officer statement that anyone tended to be violent or that anyone wanted to act in a violent manner. I'm not downplaying anything I did say, and I have never objected to the words that I said. I did say the words, fuck you, to public officials, yes. I'm not downplaying anything. I am saying that those words were used, and I'm claiming that those words, not because I'm claiming it, because it's been ruled over and over again that those words are protected, and nobody made a claim that they felt that they wanted to reach a peace. And that's what it means when it says tends to incite. Nobody's claiming that they tended to do any sort of violence towards me, Your Honor, by the simple words that were uttered.
You're saying that any objections to the video?
Which video would that be?
The one that was provided to you, Discovery.
The video that was provided to you for the trial, they want the court to take judicial notice of what happened in the video.
Is that the full video?
Yes. Well, it's the one where you're yelling and then being escorted out.
Is that just a couple seconds?
Yeah.
I would like to introduce one of the exhibits, Your Honor, as a full video, so the court can have some context.
Okay, we'll discuss that introduction. Let me first tell me if you have any objections for the state entering that video.
It's already entered, right? It's
No, it's not entered yet.
It's not entered.
I'm trying to get him to see it. It has to be entered first.
Yes, but
all right. No objections. No objections, Your Honor.
And I don't want the court to be able to see it because it has,
we'll check.
depending on the program.
Do you know the name of the file? Sure.
Judge, I think I'm going to watch here and then. Yeah, because ever since they updated them. All right.
Mr. Raza, has that video been authenticated?
Yeah.
Did
The one
you
that was submitted to you.
did you enter an authentication affidavit?
I don't need to. Can you make the image?
If he wants it to start,
it will pop up.
Fuck you all out there. Every single one of your board members. Dr. Cruz, fuck you. Trumpman, fuck you. Garcia, fuck you. Y'all cannot learn not to violate people's rights. We don't learn the hard way. Now we get order, guys. Y'all cannot learn not to violate people's
Who's the female that's on the top? Board member? Okay.
Fuck you all out there. Every single one of your board members. Dr. Cruz, fuck you. Trumpman, fuck you. Garcia, fuck you.
Just square it out. And
Did she just say get him out of here? That's what she said?
And then he comes back in.
Y'all cannot learn not to violate people's rights. Don't learn the hard way. Now we get order, guys.
That's what he says. You only learn the hard way.
In court, yes.
So it's, as the court can see the disruption that, it was, it's the context that he said it. It's the violation. And what he caused. He caused them to tell me that.
All right. Anything you want to say, Mr. Ortiz, so I can give him the opportunity?
No,
No?
that's it.
I don't have anything else, Your Honor, no.
This belongs to you, right?
Yes.
Yeah, we don't keep it, okay. Sure. So based on the information, anything else before I decide?
No, Your Honor.
Okay, given the opportunity, we heard opening statements, we heard arguments, there was some exhibits, and closing as well. So based on the information that was provided today, on the facts of this case and the situation that occurred on that day, this court is going to dismiss the charge and is going to grant the dismissal. Case dismissed.
Thank you, Your Honor.
So I have the case too.
Yes, you may.